Today's webinar is CRPs, why the insurance industry hasn't embraced them and why it should. It's being presented by Rick Boothman. Many of you know Rick Boothman as the Chief Risk Officer at the University of Michigan's Health System and faculty at the School of Medicine, who in 2001 led a transformation in the university's response to patient injury in what has become known around the world as the Michigan model. In 2006, then Senators Clinton and Obama promoted Michigan's work, and Rick was called to testify before the U.S. Senate that year. 2 years later, at President Obama's direction, the U.S. Department of Health and Human Services initiated a large national research study into the broad feasibility of the model, which ultimately resulted in the department's publication of the Candor Toolkit in 2015. So here's the good news for everybody. Rick has retired from the University of Michigan after 17 years and now consults with health systems, insurance companies, and others interested in exploring their own version of the Michigan model. He's a frequent speaker and teacher and collaborates with researchers at the University of Michigan and is a visiting scholar with the Vanderbilt University Medical School Center for Patient Safety and Professional Accountability. Rick received his law degree from the University of Detroit School of Law and now has his own consulting company, Boothman Consulting. So with that, Rick, I'm turning it over to you.
Thanks, Steve. Can you hear me?
Can hear you fine, yes.
Okay, great. Thank you, everyone, for joining this webinar. I'm not very technologically savvy, so I apologize for the slight delay, and I hope that you can hear me well. I want to say, though, that as a preamble to this, and Steve, how do I advance the slides?
I think you can just use your, just as you were, there we go, you got it. There you go. Yeah.
I got it. I'm sorry. As a preamble to this, I want to say that in 2000, as a trial lawyer, representing hospitals and doctors in Michigan and Ohio, all of this made great sense to me at the time. And it is very frustrating and a little mystifying to me why it doesn't make sense to a lot more people by now, almost 20 years later. I've worked my entire career with the insurance industry and am a fan of it for the most part. And what we want to talk about is why has the spread been so slow? And maybe what am I missing? But why I think that the insurance industry ought to take a harder look at this and question some of the old beliefs that gave rise, that I think gives rise to the reticence that exists. So a couple housekeeping matters. First is my conflict of interest disclosure. Obviously, I'm a great proponent of this, and I'm working with anybody who's interested here and abroad in this area. I also want to essentially do a disclaimer, and it's a little weaselly maybe to do a disclaimer up front. What I really intend to do today is to provoke a discussion, provoke questions and a dialogue that I'm not so sure has actually happened before now. And so with apologies, I want to get started. The most immediate impediment to spread, as far as I can tell, is still a widespread misunderstanding of what this concept is, and maybe more importantly, how it differs from past piecemeal insurance practices. The CRP concept is an amalgam of a lot of things, some of which have been done for as long as risk management and insurance has been around in professional liability settings. But just as an example of some of the skepticism and misconceptions of the model, when you look at some of these comments and criticisms that I've received over the years, they were pretty jarring. I will say that when a scholar like Troy Brennan stands up in front of an audience and says that I'm going to single-handedly bankrupt the university in 2004 I took that pretty seriously. But the genesis of these comments and also these really, I think, are lodged in a misconception of what this model really is. So if you look at each one of these comments, they all kind of bespeak of an assumed naivete on our part, that we are just willy-nilly running around doing mea culpa disclosures without regard to the financial implications or the claims implications at all. What was interesting to me is this publication in 2007 that Studdert and Mello and Gawande and Brennan and Wang, some pretty high-powered people, raised back in 2007. Now, to her credit, Michelle Mello has said publicly that if she had one article she could unwrite, it would be this one. But what's interesting to me about this quote is the underlying thinking that went behind this, and what I think is at least one major reason for people being reticent to adopt this. And it's this notion that every day in hospitals, patients experience unplanned clinical outcomes, that every single person in a healthcare setting understands that almost nothing is benign, and they can't always control the risk. I have personally represented hospitals in 2 cases where a simple prescription of amoxicillin for a kid's first ear infection had disastrous consequences. And so that's the reality that we're living in, and I think that these...
Oh, yeah, I didn't know you were a person. Nice to meet you. I remember when I first started here, there was all this awareness and training and stuff about entering PSNs and all this stuff, and I was like, so where do I do that?
Could somebody, whoever needs to be muted, could you mute?
Who told you that? I was like in an app.
Okay, thanks. Anyway, I think underneath these authors' statement is this notion that these bad things are happening in healthcare all the time. We can't control all of them. And just running around offering compensation to everybody who has a sad story would be financially disastrous. I don't disagree with that. But underneath that criticism, or behind that criticism, is a complete misunderstanding of what a true CRP is. So I have listened to these criticisms for the first 10 or 15 years. Some of them are continuing to go. But when you look at the next set of criticisms, they bespeak a different misunderstanding, and that is that we are selectively taking advantage of people at their most vulnerable time. This judge in New York's Supreme Court really went after me because, in fact, what he said was that any settlement done in our program he would have no trouble setting that aside if anybody challenged it, because he thinks without giving everybody a lawyer to talk to us, those settlements are by nature opportunistic and taking advantage of people who have been injured. Tenenbaum, this professor at Suffolk University, essentially calls what we're doing fraudulent, and that we are cooling the mark out, the mark being the victim in a con game. He really doesn't understand, in my opinion, what it is that we're doing. And more importantly, most of these people don't understand why we're doing it. So to understand what a CRP is and how it varies from the time-honored way we've handled claims in the insurance industry, you have to understand what is behind it. The motivation means almost everything. So many health systems say they're doing it now, and when I scratch the surface and do a little cross-examination, what I really find out is that insurance companies and some risk managers in hospitals are finding opportunities to settle cases early and without litigation. And they equate a CRP with essentially cherry picking or selectively settling some claims early. Well, the first thing I want to say about that is not new. When I broke into this business in 1980, I was introduced to one of the most bright and savvy risk managers, a man by the name of Dick Sardelli in the Detroit area, who was vice president of claims with the Detroit Osteopathic Hospital Corporation. And Dick really could pick them. He had been doing that for years. That is not in and of itself a new approach. But it has been an approach which has been abused over the years. So in 1982, as a young lawyer, I got a birth trauma case assigned to me. And the birth in the case happened 10 full years before the lawsuit was filed. And accompanying the lawsuit was a motion to set aside a settlement. An insurance person had shown up in a patient's hospital room after a badly managed shoulder dystocia and settled the case, presumably, for the amount of the outstanding hospital bill. In those days, it was $12,000 and change. That practice was not unheard of. So we have to deal a little bit with the unsavory baggage that early resolution has had over the years. And I recognize that, and I recognize that there are plaintiffs' lawyers who are immediately suspicious when you try to settle a case early. Those are the realities of this, but it's not the only thing that the CRP entails. So asking the question, why haven't insurance companies embraced CRPs, caused me first to take a quick and really basic look at the whole insurance paradigm, because I think some of the answers anyway are embedded in exactly the insurance model and assumptions that were made based on the insurance model. So indulge me a little bit in some really basic insurance for dummies. But I find this helpful in considering why and how we can implement CRPs in the concept. So insurance really is a simple risk-sharing concept. There's not much exotic about it, really. Prospective customers realize at some point that they are somehow involved in activities that pose a financial risk that they don't want to deal with or that they can't handle on their own. Whether it's auto insurance or homeowners insurance or professional liability insurance. Insurers seeing an opportunity to generate capital, and I said it that way specifically because the real way an insurance company makes money is investment of the premium dollars that they don't have to keep in reserve to make more money through their investments. But insurance companies a long time ago saw an opportunity to generate capital by agreeing to accept a component of the risk. So true full indemnity across the board is very rare in our society, but there's a lot of examples of selective insurance. And there's all sorts of ways of carving out what is the risk that an insurance company is taking. But that's essentially the model. For a fee, we call premiums. An insurer will accept a certain component of an insured's risk. And then they take the money and they project what their losses may be. And they accumulate enough of it and basically invest it in capital. It's a pretty sound business, kind of legalized gambling, but a pretty sound business concept. And then we expect both insureds and insurers to take their own steps to ameliorate risks behind the scenes. So insurers, I have some pretty pithy examples, but insureds, for instance, might buy safer cars, or they'll stop driving when they become risky. They may do all sorts of things, shovel the snow rather than risk somebody falling off their porch in the winter. Those are all simple examples of risk management or risk amelioration. In medical liability circles, what we really hope our insureds do is stay focused on the safety of their medical care and try to do their best to control the risks that they can control. And a couple of examples that I've listed are things like robust safety, patient safety programs, attention to cultures and clinical cultures that favor openness about incident reporting, robust root cause identification and clinical care improvement, rapid improvement cycles so that more patients are not unnecessarily exposed to known risks, data analytics, peer review programs, and other resources that should be aimed specifically at improving safety and quality. Unfortunately, in 40 years at this business, I have been discouraged to see even some of the best healthcare corporations in the country not prioritizing patient safety and quality. And I think that there's a couple of key reasons, but examples of this would include things like academic health systems that perhaps put a greater priority on NIH funding than they do on the quality and safety and patient centricity of their clinical care. Many years ago, I represented a small community hospital, and I received a case just before I left private practice of an orthopedic surgeon who had done some pretty awful things with a bilateral knee transplants or knee replacements in a lady with very badly complex medical issues. And she died a miserable death from that. And when I got the case, I sent a letter to the hospital after sending a law clerk to the court to find out how many times this doctor had been sued. And I discovered he'd been sued 32 times. So I sent a letter to the hospital and I said, we'll do our best on this malpractice case, but you really need to trigger your bylaws provisions on peer review and take a hard look at this physician because he's been sued 32 times. And I got a pretty shocking letter back. And the letter said, we hired you to do the malpractice case. We'll take care of the rest of this. And by the way, this guy single-handedly keeps our orthopedic wing afloat. No, we're not going to do anything about him. I've seen that examples of the failure to prioritize patient safety across all spectrums. And we can't assume that insured hospitals are going to do it. But why? Well, I think there's a couple of reasons. First, there is an ambiguity in medicine that's almost unique to medicine in the field of personal injury, in which, as we all know, you can do everything right, or at least everything reasonable in the course of caring for a patient and still have a bad outcome. Medical providers, no matter how careful they are, cannot control all of the risks or clinical outcomes. And so I think there's been a resignation over the years that no matter what we do, we're going to get sued, so let's just not worry about it. That's, I think, a big part of this. And secondly, there are so many competing priorities in medicine. So do clinical leaders seize on this reality that there can be bad clinical outcomes no matter how high quality their work, and then pay attention to other financial performance issues or other kinds of things like NIH funding and research activities? After almost 40 years in the business, I tend to think that these are operative behind the scenes in the insured's camp, and we need to pay attention to that, because if we're an insurer, we can't assume that there is a single laser-like focus on quality and safety with all of the healthcare organizations that insurers insure. So while that's a problem, I will also say, whether this is a convenient excuse or not, that many of the healthcare organizations I've represented and some I've worked for often make excuses for not doing, say, robust peer review because of the fear of litigation. And this happens to be often a convenient excuse, but it's fueled a lot by lawyers' advice to not admit when they've made a mistake, to not step forward when a patient has been harmed through unreasonable medical care, even to not participate in things like patient safety organizations. I listened to a very experienced and eloquent healthcare lawyer only last year at a conference in Chicago tell a whole audience why that their employers should not participate in patient safety organizations because of the fear that their dirty laundry would somehow come back to haunt them. It's that kind of advice that has an outsized impact on the community of insureds out there, And I think we are partly to blame for the healthcare community not maximizing their efforts in quality, safety, and risk. Insurers, on the other hand, aggressively ameliorate their risks in a lot of excellent ways. So there are contract ways, and as we are all familiar with, things like policy limits and deductibles and exclusions, and there's also business decisions about offering certain lines of coverage on certain medical specialties in certain places in the country. Even the claims made versus the occurrence-based coverage products that have emerged in the last 20 years, I think is a way to ameliorate some of the risks rather than run the risk of a catastrophic case jumping out of the weeds 20 years after it happened. Claims made policies attempt to put a limit on what the duration of risk that the insurance companies and insurance industry have accepted. All those things make perfect sense. Cancellation and non-renewal practices are also used, but I worry that sometimes those things are counterproductive, and I'll get to that in a few minutes. There are also claims management strategies that are designed to save costs. I competed with a lot of excellent trial lawyers in the Detroit and southeastern Michigan area for 20 years, along with my partners, and I know full well the pressure on us to bill at lower hours or lower cost per hour. There also were all sorts of, in the final days of my private practice, restrictions on experts, restrictions on whether we could take depositions out of town versus video. There's all sorts of those kinds of things that have come into play. Even use of auditors looking at lawyers' bills, of course. And then there's the broader picture, the legislative and public relations. There have been in the last 20 or 30 years intense lobbying for tort reforms, which often have taken the shape of limiting recovery, searching for caps on recovery, as we have in Michigan with caps on non-economic recovery anyway, reducing time allowed for bringing claims, and then strengthening rules of evidence in the courtroom about what experts would be allowed to weigh in on things. When I first started in practice, there was an expert in the Detroit area named George Miller, who was a general practitioner, and I saw him testify on all sorts of things. But obviously in the last 30 years or more, we've had restrictions on qualifications of experts. These are all ways of ameliorating risk and making the risk that the insurance industry has accepted a little more predictable. And as far as predictive resources go, of course, there's heavy use of actuaries who predict, usually with national trends. And some places use questionable reserving practices like stair-stepping reserves in order to maximize the amount of money they can shift over to investments. I happen to think, though, and my point of this talk today is, I think insurers are still leaving serious money on the table. And I ask a number of questions like this. What if many of the mitigation strategies are aimed at symptoms of the problem, not causes of the problem? I happen to think, after all these years in the business, that attention to the litigation costs or attention to caps on recovery without getting to what gives rise to the claims is a little bit like treating a pneumonia patient only for his or her fever. Without getting to the underlying infection, all you're going to do is blunt the short-term impact of some of these claims. And I tend to think far deeper than that. I think, and I would urge the insurance industry also to think far deeper than just looking at ways to ameliorate the cost of claims. What if your practices actually increase costs unnecessarily? I'll get into how that's pretty clear, in my opinion, by requiring people to bring claims before they engage a patient. It seems to me that many companies' practices actually increase their transactional costs unnecessarily? What if traditional practices actually perpetuate the cost of avoidable patient injuries? I will tell you, and anybody who's been in the business as long as I have, we've all seen those cases where behind the scenes our clients say to us, this really isn't great care, but we can find a malleable expert to defend it. What really happens in the long run is we end up protecting questionable practices and questionable practitioners. The OBGYN I spoke of earlier in the 1982 birth trauma case that I got that was supposedly settled in 1972 had 4 birth trauma cases after the delivery in 1972. 2 of the 4 were mismanagement of shoulder dystocias. If there had been a more robust attention to that case that everybody knew when that baby was born that shoulder dystocia was mismanaged, it might have saved a lot of heartache, a lot of injuries, and a lot of money. What if insurers could alter your practices to encourage and not frustrate an interest in more durable fixes? As I said before, too often lawyers' instructions and lawyers' advice shield questionable practices and questionable practitioners. But what if we change the dynamic a little bit and focus on the longer term? Could we actually reduce in a more durable way the kinds of malpractice claims we see and get the legitimate ones resolved quicker and cheaper? I think so. And I think that was the experience we had in 17 years of doing this at Michigan before I retired. And lastly, what if we all refuse to accept that malpractice is just the cost of doing business? Not all malpractice costs are inevitable. And if we pay attention to the deeper cause for the malpractice cases and the patient injuries that are avoidable, I think we can actually have a much more favorable financial impact in this professional liability world. So how does a CRP approach differ from traditional responses? Well, let me just indulge me for a minute and let me run through the essential elements of a CRP. First, I want to say that the goals are radically different. The goals for most deny and defend and even selective early settlement practices are largely short-term and are largely focused on ameliorating the financial loss. So I can understand the business side of this, but it doesn't get to the root cause of why patients are harmed in preventable and avoidable ways. A CRP's goal, on the other hand, is to foster an accountable healthcare culture that prioritizes safety and continual clinical improvement, and, by the way, more durable claims reduction. It's really important to understand the distinction here. You're either in it for the short term and you're just dealing with the claim that's on your desk and what is the best way of ameliorating that claim, or you're thinking a little more long term and you're thinking to yourself, boy, if I cheat somebody, or if I even win a case that I shouldn't win, have I really done that insured, and have I done my company a favor in the long run? I tend to think not. And look at the essential operational elements of a CRP. Well, it starts with notification of an unintended clinical outcome. So many insurance companies these days require a claim to be asserted. They've already lost an opportunity to possibly engage that patient, maybe with an explanation for why they don't have a claim. And a lot of time passes and a lot of things happen before a claim gets asserted. Notification of an unintended clinical outcome is the first element of this, and the next 3 elements all happen simultaneously. What we want in a true CRP is to do this in a systematic way. I want to receive all unintended clinical outcomes, and I want to triage all of them. And then when they happen, I want to do 3 things as soon as possible. Stabilize the clinical environment and protect other patients and our staff from the same thing that's happened while we're sorting out what happened. Support the patient as quickly as possible listen and get the patient's side of it, because for most clinical adverse events, we will never fully understand what happened if we don't know what it appeared like, if we don't get the patient's part of it. And too often, we stonewall patients and never even ask those questions. Similarly, we have to do the same thing with our caregivers. We need to get to the caregiver as quickly as possible, listen, and promise full disclosure. Those are the first three things you do after you learn about an unintended clinical outcome in a true CRP. That's followed by normalizing honesty through a rigorous investigation. And this is where all of the critics who have thought that this is Pollyanna or hopelessly naive and would bankrupt the system, this is the part that they miss. Key to this is getting on top of these events as quickly as possible and as honestly, brutally honestly as possible. We talk about disclosures to patients, but the real truth is the first disclosure is the one we make to ourselves in that minority of adverse events in which we conclude we could have and should have done better. That's critically important. And that's a clinical decision. That is not a legal conclusion. But in a true CRP, we want to arrive at that as quickly as possible. This whole business of patient disclosures is not a single conversation, but it's really a relationship and a promise that as we get to the bottom of it and we get it right, we will next share the facts and conclusions openly with caregivers and patients alike. And I will say that in my time at the University of Michigan, the vast majority of the time, this took the form of explaining to patients why they didn't have a claim or why the care was reasonable under the circumstances. Isn't it better to have control over that dialogue early on rather than wait until a claim is asserted and lawyers are already invested in a case? I happen to think so. But sharing those conclusions openly with caregivers and patients alike brings a measure of clarity. And I fully understand that not every case is a black and white case. There's lots of gray areas, but arriving at these conclusions in a credible and competent way gives us a clearer path about how to move next. We want to be principled and accountable, because if our goal is the culture, not just ameliorating a single case, then cheating a patient in the short term, like they did with the birth trauma case in 1972, is actually counterproductive to the goal of a CRP. We don't want to necessarily reduce all claims. What we want to do is right-size them. We want to make sure that we are only paying where we should pay. But by being accountable, it allows the health system, it allows the insureds to understand what the price of poor care is compared to the cost of doing business. It's a much more rich conclusion. Next, we want to make sure that we leverage lessons quickly in safety and quality and peer review. I have been challenged by countless lawyers who think you cannot combine these things, that the last thing you want to do is start a peer review before you even know if a patient's going to sue you. When you think about how unethical and immoral that is, because basically what they're saying is we're happy to put other patients at risk while we see what happens with the potential case today. That doesn't even make sense to me, let alone seem an ethical idea, but we've done that for years. And lastly, measuring improvement. What we should not be focusing on entirely is the malpractice cost. We ought to be looking at the recidivism of clinical errors that happen to repeat themselves. It means that our root cause analysis is not robust enough, or our improvement cycle is not robust enough. In a CRP, the metrics really matter. And the metrics are different than a traditional risk management, claims management approach. So just looking at some of these things, the CRP depends heavily on the ability to recognize and capture adverse events, unlike the practices of many insurance carriers that require a claim to be asserted before they even get involved. In a CRP, healthcare providers and organizations immediately support the patient and family. All of the research that has been done that examined why patients sue their caregivers have yielded the same 3 themes. And they are not, I want a windfall financially. The same 3 themes over and over have been reproduced, not just in this country, but in the same studies done elsewhere. And that is, I couldn't get the most basic answers about what happened. Nobody seemed accountable. And I am intensely worried that this is going to happen to somebody else. By stonewalling patients, as we have advised historically, by telling caregivers, whatever you do, don't make any admissions to that patient and don't even talk to them if you can avoid it. What we've really done is pushed patients to lawyers and bought ourselves malpractice claims without having an opportunity to even control the dialogue. Healthcare organizations immediately support their staff in a true CRP because they realize that safer caregivers deliver safer and higher quality care. The evidence for that is unmistakable. And yet, for generations, we have essentially isolated caregivers who are told not to talk to anyone. I can't tell you how many physicians I've talked to who think that when something bad happens, they can't even speak with their spouse at home. It leaves them feeling isolated. It leaves them feeling like they're the only ones who have ever made those mistakes. And it actually contributes pretty palpably to burnout and physicians leaving the practice. It's not been helpful to us in the long run. In a CRP, we prioritize immediate safety so no one else is harmed, but many health systems I know believe that what they should do is not make any changes clinically until they see whether or not they're going to get sued after an adverse event. In a true CRP, there's commitment to true transparency because that is the only way we will improve. It also happens to meet the ethics of the healthcare profession in the short term. But many rely on lawyers in litigation before they even pay attention and ask their question, is this a case we should fight or is this a case we should defend? And then the decision as to whether to defend it or not becomes based on litigation factors, not clinical factors. And here's what I mean. I published our first paper in the journal, in the American Health Lawyers Association journal back in 2009, and we used as an example a misdiagnosis of breast cancer. In that case, I had 4 or 5 expert reviews. And all but one said exactly the same thing, that when this patient complained of a mass in her breast and the primary care physician couldn't feel it, it was still incumbent upon him to do either a mammography with an ultrasound focus in the area she was pointing to, or at a minimum, a short-term follow-up to see if the mass was still there and she could still feel it. One of the 5 experts I went to said, yes, that's the standard of care, but I can still defend this. And he constructed what I recognized was really not a very honest way of defending it. We chose to settle that case, of course, but my point is that there are experts who will tell us in litigation all the time that we can defend a case in this way or that, and then we'll rely on the weaknesses of the litigation system and perhaps out-lawyering the plaintiff's lawyer as a way of winning the case. I think that that has been short-sighted, and we have essentially protected questionable clinicians and questionable clinical practices. That has not helped the insurance industry, and it certainly hasn't helped medicine. In CRPs, we intercept litigation. As I said earlier, every study that has been done to look at why patients sue their caregivers identifies the same factors. And yet, the failure of transparency and communication, the decision to not explain to a patient, forces patients to actually think to themselves, maybe I need my own advocate because I can't trust what I'm hearing or I'm not hearing anything. We have driven patients to lawyers over and over again for generations. Accountability demands that principled decisions about compensation align with the clinical assessment. In other words, I can ask risk managers and have asked risk managers all over the country 2 questions. The first, I'll bet you can tell me to the penny how much your malpractice expense was for the prior year. And they almost always can. They almost never can answer the next question. How much should you have spent? Because no matter how good the health system is, they are not beyond making errors that they shouldn't have made. And yet, by not distinguishing between meritorious and unmeritorious cases, by defending all of the cases as though patients were not entitled, we've actually lost sight of what the cost of our substandard care really is. Compensation decisions in a CRP are highly principled. And as I said on this slide, I also believe nuisance settlements are as toxic as not fairly compensating deserving patients, because what happens is the care providers look at what happens in these after an adverse event, and they just chalk it up to a big game. And they accept no blame for the cases they should accept responsibility for, and chalk it up all to an insurance and lawyers game, and there's no accountability at that point. So I think compensation decisions in a true CRP, with some variation. I mean, I'm not naive. I understand that there are cases for defensibility reasons or other reasons you still have to think about settling, even though you really believe in your heart the care was fine. But for the most part, the compensation decisions follow in a CRP the decision on the rightness or wrongness of the medical care. Just to give you an example of how valuable that can be, one of the last things I did before I left the University of Michigan was to do an analysis of the prior 10 years of large case costs. And this was both transactional costs as well as settlements and legal fees and everything else. The number was huge. 76% of that, by our own analysis, was our fault. And you can take that, once you do that discriminatory evaluation, you can take that number, and in business circles, that's a very powerful argument for putting more money into patient safety, putting more money into patient centricity. But you can't do that if you believe that malpractice is simply a cost of doing business, that the medical provider is the victim in this whole thing, and that settlements are always going to be made no matter the merits or the lack of merit of anybody's claim. We accelerate and hardwire sharing lessons learned to promote clinical improvement. I think the import of that and the value of that is pretty self-explanatory, but litigation has impeded this, and I have seen this over and over again. Ask yourself why hospitals continue to have falls or continue to have people like that OB-GYN that I referred to earlier from 1972, who stayed long enough to have 5 total birth trauma cases before they finally got rid of him. The end data analysis I've just referred to, being able to discriminate between substandard care and attaching a cost to it, really drives better resource allocation. And I think that when we, in a knee-jerk fashion, tend to defend everything that comes down the pipe, we lose this ability. So I think the claims management practices, when we look at them, I believe strongly that the quicker an insurance company confidently concludes that a patient should be compensated, the better. You can get rid of and avoid not only the transactional costs of hundreds of thousands of dollars of legal fees and expert witness fees and those sorts of things, but I will also say categorically that there is a psychological value that translates into a dollar value. When a patient is forced to go through 2 or 3 years of litigation and drag a settlement out of a healthcare provider where their settlement was warranted, you always pay a premium. The sooner you can come to the table, the sooner you can say with confidence, not with naivete, we're very sorry that this happened, this shouldn't have happened. We can now talk about the actual cost of the error and not talk about the lottery discussion that goes on in a litigation circle along the lines of, I can try this case 10 times and here's the range of verdicts. It's a clinical decision though, it's not primarily a legal one. And the sooner you can get to an adverse event and start looking hard at the clinical practices and arrive at a legitimate conclusion, one way or the other, the better. And either provide that patient with an explanation for why they don't have a claim, which was, by the way, the greatest source of our savings at Michigan, or step up and resolve the case for a reasonable price, the better. Litigation is grossly ineffective at doing this and grossly inconsistent. And as all of us should know, that by the time a patient is litigation directed and a trial lawyer has already invested in it, it's pretty hard to talk them out of it. Now you're in for a longer fight. So after 40 years in the business, and I'll wrap this up and be happy to take questions, but I want to offer you 3 takeaways to at least think about. And every insurance company will be different. Some insurance companies have rules about when to make claims or whether they will get involved before claims. There are cancellation practices that can chill an insured from advising an insurance company of an unanticipated clinical outcome before a claim is made. These kinds of things I think we ought to have a hard look at. So first, insurance, I think you're leaving serious money on the table with claims management practices that do these things, that drive injured patients to lawyers needlessly, that ignore excellent opportunities to explain cases that aren't meritorious, to ramp up settlement amounts and transactional amounts by not confronting meritorious cases quickly. I will never understand some of the assignments that I got as a trial lawyer where it was crystal clear that medication errors or something else bad had happened, but it was still waited, they still waited until there was litigation and then triggered my involvement as a trial lawyer. And then perpetuating poor clinical practices and protect challenged physicians by defending care we should not defend. I recognized as a trial lawyer that the longer I practiced, the better I got in the courtroom and the better I was at winning cases I shouldn't win. I wasn't doing anybody a favor in those days. Secondly, I think insurers too often chill the insured's quality, safety, and risk steps that they might otherwise take. We should pay attention to the longer-term implications of some of the short-term advice that we've given our healthcare insureds, because I think in the long run we can contribute to an improvement of medical care and a reduction in claims if we think differently about it. And lastly, of the 3 takeaways, I believe that we will always have litigation with us, especially in this increasingly polarized society, but I would not give up. Abandon that resignation that it's all a cost of doing business. It doesn't need to be. We produced at Michigan a remarkable reduction in our claims that has persisted right to the day I retired. And despite the fact that I've heard actuaries talking about rising claims these days and rising costs these days, we didn't see that at Michigan. And I think it's because we were safer. So my advice to you is adopt a loftier goal than simply ameliorating the short-term risk. Partner with your insureds to be principled, accountable, and safer. Pay attention to the practices that maybe your company has that could actually work at cross purposes to being safer. So rethink those practices, especially the ones that discourage calling you as the insurer with fresh adverse events. Sometimes the very best opportunity to avoid a lawsuit is in the early stages of those events after something bad has happened. And going to the patient side for the caregivers is actually like falling off a log to them. All they need is permission. One of the most remarkable things about the CRPs that we've been able to introduce is how it resonates with the healthcare community once you tell them that it's okay, that the ceiling is not going to fall in, that they're not going to create a disaster. And lastly, as I said, litigation may be inevitable, but encouraging this approach will encourage an improvement in the clinical care and a durable drop in claims. but that's my advice for you, and those are the three things I have for you to think about. But I'm happy to take any questions or comments or criticisms.
Thank you very much, Rick. All the phones are unmuted now. If you're not asking a question, please mute your phone. And if anyone has any questions, go ahead and ask one. Any questions?
Any comments?
I'm sorry, who's that? Rick, can you hear me?
Yes, I can.
So I actually did have a question. From your experience, do you think that the insurers are starting to embrace this, or do you think that there's still a tremendous reluctance, to get involved?
Yes and yes. There are insurers that have and continue to express interest in this. I have heard, for instance, that Beta, which has supported the collaborative, has moved considerably in this direction. I haven't spoken to them directly, but so I don't know how systematic it is or if it's still more of a selective settlement approach. The insurance companies that I have spoken with, for the most part, who think they are doing this, most of them are still selectively settling cases rather than seeing it as a systematic way to actually contribute to the culture and the more durable claims improvement, though.
So, many of us are self-insured, and we often fight battles internally, which I know you've gone up against. Do you have any suggestions for us in terms of how to fight our in-house battles at all to push this through?
Well, one of the things that I've realized is that for so long, this has been the province of lawyers and insurance companies, rather than, and that we as lawyers, and I'll take blame for this too, we as lawyers have looked at it through a litigation lens, but not asked ourselves, are what we're doing counterproductive? Are the things that we're doing actually counterproductive to the healthcare interests of our insureds? Are we taking short-term measures because we as lawyers are trained in to see worst-case scenarios? Are we advocating things that actually maybe in the short term make us feel more comfortable, but in the long term perpetuate the problem? One of the things that I realized is that once we get out of the way and constantly fixate on the clinical mission and ask ourselves, what's the best way to handle this in furtherance of the clinical mission, I think was one of the cardinal things that we learned, and I'm grateful for the General Counsel's office at the University of Michigan that saw that pretty clearly and didn't waver. So a good example is the lawyer who says, and sometimes the financial person who says, geez, if it's going to take us $100,000 to try this case and we can settle it for 50, let's just settle it. That may make sense in the short run, but it doesn't make sense to the broad audience of caregivers that watch that and then walk away thinking it doesn't really matter how good I am, that if something goes wrong, they're always going to cut a check. That's counterproductive to an accountable culture, clinical culture. And without an accountable clinical culture, we won't see sustained clinical improvement and a durable reduction in claims.
So I have a question. This is Tom Green. I would be interested in your thoughts about how much of the resistance from from the insurance industry has to do with the financial impact that it may have on our own business, particularly from a lawyer's point of view? In other words, do they see this as a negative impact on their business or a positive one? And related to that, are their values are more in line with their business interests than their what the clinical welfare of the patient is? It seems to me. And how do you get that to change?
Tom, I don't know that the insurance industry is that cynical. At least my experience hasn't been like that. I don't often see them saying, "Oh, the patient be damned," and this is our business. What I personally think happened, but this is just my own reconstruction of events. When insurance was originally sold, the whole idea was, from a marketing perspective, to impress on potential insureds the potential catastrophic impact to them. So there was, and there tends to be, and I still see it in advertisements, there tends to be a marketing mentality that says every patient that gets hurt could represent financial ruin for you. That's why you doctor, need to pay high premiums for this coverage. And I think you can get locked into that mentality and start to see every single injured patient as a potential adversary, when in fact, by engaging them, we discovered at Michigan in a humbling way how forgiving patients are once they are allowed to understand what happened. I just think personally that the industry has been locked in that mentality for so long that it hasn't occurred to them that you can engage people and people don't behave so malignantly. There's I think fear is the bigger impediment than business interest. I think the worry that somebody is going to say the wrong thing and it's going to result in a catastrophic settlement or verdict scares the heck out of people, when in fact our experience over 17 years has been exactly the opposite.
Great. Well, Rick, thank you very much. I appreciate this. We're at the top of the hour now. Thank you all for participating, and the webinar along with slides will be posted on the Collaborative website in probably 3 or so weeks. So feel free to go to communicationandresolution.org, and if you haven't been there yet, we have a really great CRP tools and resources page, and you'll be able to find the webinar. So Rick, thanks. Go ahead.
And I just want to say that anybody who has a question that didn't get to ask it, please feel free to email me, and I just put my contact information up. Happy to correspond with anybody.
Right, and Rick's information will also be posted as well. So thank you all very much, and Rick, thanks very much. It was fantastic.
Very good.
Thanks, Steve.
And that ends today's webinar.